The next matter to come before us is CitiMortgage versus Cathy Lehner. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you, the appellant, wish to reserve any time, and you let me know when you get started, I'm keeping the clock and can keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are.
May it please the court, I'm Grace Overdruck and I'm representing appellant Cathy Lehner, and I'd like to reserve 5 minutes for rebuttal, please. Appellant Cathy Lehner filed an answer in this foreclosure case that specifically denied that appellee CitiMortgage Inc. complied with all conditions preceding to foreclosure regarding acceleration of the note and mortgage. Appellee CitiMortgage Inc. was not entitled to a judgment of foreclosure because when CitiMortgage Inc. moved for summary judgment with the affidavit of Ryan Daly, the affiant Ryan Daly never stated that an acceleration letter was sent to appellant Cathy Lehner, and there was no acceleration letter attached to his affidavit as an exhibit. In the Ohio Supreme Court case, Kincaid v. Erie, involved an insurance claim, and the court held that there was no justiciable controversy when the person tried to sue for failure to pay a claim and didn't give notice of the claim. And by a similar analogy, CitiMortgage Inc. is not entitled, by virtue of the language in paragraph 22 of the mortgage, to file for foreclosure until they've sent this acceleration letter with the specific language required in paragraph 22 and given appellant Cathy Lehner the chance to cure the default. And in this case, the affiant never stated that an acceleration letter was sent, and there was no acceleration letter attached to his affidavit as an exhibit. This becomes especially important on the summary judgment motion because appellant Cathy Lehner did file an answer where she specifically denied that an acceleration letter was sent.
Counsel, regarding the conditions preceding the acceleration, weren't these issues fleshed out the first time there was an appeal on this?
For the first appeal, a summary judgment motion was granted. It was unopposed right before the appellant was able to obtain counsel. So the first appeal involved a motion to vacate. And in that first appeal, the court had actually held that she should have filed a direct appeal of the judgment of foreclosure. What makes appellant Cathy Lehner's case different is after the 9th District Court of Appeals rendered the decision in the first appeal, another defendant in the case, Dwayne Holt, filed a motion to vacate due to lack of service. Since he was a party named in the complaint, the trial court ultimately vacated the decree of foreclosure. And once the decree of foreclosure was vacated, there was no final judgment. So now Cathy Lehner is in a position where she can file, and did file, a direct appeal from the decree of foreclosure. And so the issues in this appeal are separate, because the first appeal dealt with the motion to vacate and the ultimate decision that she couldn't raise these issues with the motion to vacate.
But now the order that you reference, as I understand it, the trial court specifically indicated in the order that it did not have any effect on the other parties and it preserved the judgment as to them. So how is it that you argue that it is
I think where we're going, Your Honor, is Dwayne Holt had filed a motion to vacate due to lack of service to him. So the lack of service to him wouldn't affect service on Cathy Lehner. And I think that's what the court was saying, that the summary judgment, they're not going to change the summary judgment decision against Cathy Lehner on Dwayne Holt's motion to vacate for lack of service. But because they didn't have a valid judgment against all the parties, there was no valid decree of foreclosure. And the decree of foreclosure is actually the judgment that needs to be appealed in a foreclosure case to the Court of Appeals.
What did you attach to your notice of appeal?
The notice of appeal that was filed, I think it had attached the decree of foreclosure, because that's the judgment that people appeal from in the foreclosure case.
Which decree? The one that came came out after the first appeal?
Yes, because that would be the official decree. The old decree of foreclosure got vacated. The default judgment against Dwayne Colts got vacated, and the old decree of foreclosure got vacated. So the decree that's attached to the notice of appeal was the new decree of foreclosure.
So might it be the situation that the vacation of the prior decree and the institution of the later decree means that the appeal is timely, but because these arguments have been previously presented, that it is also barred?
I would agree that it's timely. I think it's not barred because it was barred in the context that it was a motion to vacate, which shouldn't have been used as a substitute for the direct appeal. And now, because of the unusual circumstances of getting the actual decree of foreclosure vacated, that then allows her to appeal now from this decree of foreclosure, because once the decree of foreclosure was vacated, there was just that summary judgment decision, which of itself, it's not a final appealable order. You need to have the decree of foreclosure in order for it to be appealed. And there's a case out of the second district called Wells Fargo versus Global, where there's an issue where a summary judgment had been granted, and the court ultimately reversed it because one of the parties, they didn't have a valid judgment against one of the parties. And you didn't need to have a valid judgment against all the parties in order for there to be a valid decree of foreclosure. And so that's somewhat similar to what happened in this case, except Dwayne Colts had the judgment vacated due to lack of service against him. And this court, in Bank of America versus Loya, Bank of New York versus Valava, and Deutsche Bank versus Dvorak, has reversed summary judgment when the affiant lacked personal knowledge. And Appellant Cathy Lehner would argue that the affiant Ryan Daly lacked personal knowledge to support a summary judgment motion against her. In his affidavit, he states that he was authorized to execute the affidavit, but that's unclear whether he's even actually an employee of CitiMortgage or under what basis he's authorized to execute this affidavit. He also states that he reviewed electronically imaged documents, and he never stated that he viewed the original note or even that CitiMortgage Inc. had possession of the original note. And he didn't state that he compared the original note to the copy of the note attached to his affidavit, which is the standard in Wachovia Bank of Delaware versus Jackson in paragraph 49. It said for an affidavit to be sufficient in a foreclosure case, the affiant should say that he compared the copy of the note attached to his affidavit to the original note. And this court in Bank of New York versus Mahalka cited to Wachovia Bank of Delaware versus Jackson for the standards regarding affidavits and reversed summary judgment because the affiant in Mahalka didn't explain how her job duties led her to have knowledge about the account. And we would argue that the same thing applies in Appellant Cathy Lehner's case, that Ryan Daly saying he's authorized to execute his affidavit and not explaining his job duties didn't give any indication that how he would have knowledge about her particular loan account records. And this court has also held in George Baker versus Reynolds that the affiant must explain their job duties in order for there to be personal knowledge. As I mentioned before, that this affidavit never stated there was possession of the note, either when the case was filed or currently when they had moved for summary judgment. And this court in Bank of New York versus Valava had reversed summary judgment when the affiant had actually used the statement that the note was possessed directly or through an agent. This court found that that wasn't sufficient for personal knowledge. Ryan Daly's affidavit doesn't state anything about possession whatsoever. Also, in the case Deutsche Bank versus Dvorak, this court held that in order to support business records, you need to have them attached if there is a statement, that there's no hearsay exception for the testimony, that if these records were regularly conducted activities, that they could be admitted, but you actually had to have the record attached. And that's also sufficient under Civil Rule 56. In order to have this affidavit be considered, whatever record that's been reviewed needs to be attached. And so in paragraph 7 of Ryan Daly's affidavit, he states that the loan's been accelerated. But he doesn't say that an acceleration letter was mailed, and more importantly, there's no document attached to his affidavit as an exhibit. And as I mentioned, paragraph 22 of Cathy Lehner's mortgage specifically requires that an acceleration letter be sent to her prior to foreclosure, and that this is a condition precedent. And
Counsel, you're just now reaching that 5 minutes. You can continue or reserve as you wish.
I would only add that in Wachovia Bank of Delaware versus Jackson, the court held reverse summary judgment and held that even if a summary judgment motion was unopposed, that doesn't mean that summary judgment should be granted if this affidavit is deficient.
May it please the court, my name is Harry Finke and I'm here on behalf of Appellee CitiMortgage, which requests that the court affirm the judgment of the trial court. I'm going to be very brief unless the court has questions, because I think the issue on which the court can dispose of this case is relatively simple. As your honors know, this is the second time we've been before the court in this case. I won't go through the entire procedural history unless the court has questions, but we're left with one appellant and two issues. Both of those issues relate to the Ryan Daly affidavit, as Ms. Stoverbrook has said. Both of those issues could have been raised in a direct appeal, and one of them, the identical issue, was raised in the 60B appeal that was our first trip to this court. The attack on the Daly affidavit, Ms. Lehner did not respond at all to the motion for summary judgment. The court entered its judgment and decree of foreclosure. In all the subsequent proceedings, those judgments remained in place. There was never a direct appeal. As this court recognized in its first opinion, any issues that could have been raised in a direct appeal were barred by res judicata, and the issues with respect to the Daly affidavit could have been raised in a direct appeal. On the same basis that the court rejected appellant's arguments in the first appeal, that the court should reject her arguments in this appeal, because again, all of those arguments are barred by res judicata. Unless the court has questions about the substantive arguments, I think if you've read the briefs, you're aware that there was a later affidavit that Citi filed in its subsequent briefing that took care of the issue about the acceleration notice. A copy of that notice was attached and affiant authenticated it properly. So even if there was some problem with the Daly affidavit, it was corrected before the trial court, and any error would have been harmless because it was clear on the record that there was a proper acceleration notice sent to Ms. Lehner.
Counsel, it seems as if, I thought about that in reading the briefs, that we have said that when evidence is presented in a reply to which the opposing party does not have the opportunity to respond, that it's inappropriate for the court to consider that. That was not raised as a part of an assignment of error here. So
In your honor, it's a little different because this was supplemental briefing. I don't know that the parties did not have a chance to respond to their supplemental briefs. Neither one did. I don't know that the trial court would have prohibited it. It wasn't like, motion, response, reply, and that's it. So it's a little different situation here. Unless the court has questions, I'd simply ask on behalf of CitiMortgage that you affirm the judgment of the trial court. Thank you.
I'd like to address what Judge Moore just brought up. In our reply brief, we cited the HSBC versus Byrne case, which is out of the 9th District, that deals with the issue that this court has held that in summary judgment cases, you cannot submit new evidence in a reply brief, and that can be considered. And so, when we're dealing with the actual summary judgment motion and affidavit filed in support, we've got that affidavit of Ryan Daly that does not have an acceleration letter attached. In addition, the acceleration letter that was later attached came with supplemental motion briefing on the motion to vacate. And the first response to the motion to vacate did not mention that an acceleration letter was sent and did not have the one attached. I believe the issue with the trial court that the trial court set a supplemental briefing date and there was no response period for responding to the affidavit of Jared Cathy that was ultimately submitted.
Was there any request made?
I think it was submitted, you had to have it submitted the day before the hearing date. So I think it was one day and then the next day was going to be the ruling. So in that case, I don't think there was even service of the affidavit until probably the day after the hearing. The hearing's at 9 a.m. Service of the motion probably wouldn't have been the earliest until the afternoon of that day. Even the affidavit of Jared Cathy is questionable because he doesn't authenticate any way of how it was mailed to Cathy Lehner. There's no evidence in there. Well, it's also an issue and a factual issue for trial because on summary judgment we're looking at what's a factual issue. The affidavit of Ryan Daly was executed in April 2011, which was shortly after the complaint was filed. And so he would be in the position, the best position really, to know if an acceleration letter had actually been sent to Cathy Lehner at that time because he would have been reviewing the records closest to when this foreclosure took place. And so even though this letter may have been produced much later, there still would have been a factual issue to challenge because we have an affidavit from Ryan Daly where there is no letter attached and no statement about a letter being sent. And when appellant Cathy Lehner filed her answer to this case, she had stated that she didn't receive an acceleration letter. And I just wanted to mention here that the Kupta case is distinguishable from this case because of that issue with Dwayne Holtz vacating the judgment. And then the actual decree of foreclosure being vacated, which then creates a new decree of foreclosure, and Cathy Lehner has now filed a direct appeal from the new decree of foreclosure.
And so we would argue that it's distinguishable on that basis, but it still does not, that does not obliterate the concept of res judicata. Just because the facts are not the same as in Kuchta. There are a line of cases that say that, you know, you have issues that could have been raised at all these various times in the past, and you didn't raise them, that they're barred.
Your Honor, because the judgment, the actual decree of foreclosure was vacated, and we have a new decree of foreclosure, this is like a direct appeal from the original summary judgment.
You don't, so, I hear you, and I read that, but you didn't cite any case to support that.
I think I cited just a statute about, or maybe Civil Rule 54B about final appealable orders. And so, because this case is also different than some of the other cases out there, because we have that specific denial, which created a factual issue for summary judgment as well. And so this summary judgment, which would be a de novo review, which we'd argue is a de novo review up to this court, because she's now directly appealing from that summary judgment by appealing from this new decree of foreclosure. And so we would argue that her arguments weren't barred because they couldn't have been legitimately or legally raised before, because this decree of foreclosure is the actual decree of foreclosure.
And counsel, I need to inform you that we've reached the end of the 15 minutes.
Thank you.
We're out of time today. Thank you both for your presentations today. The court will take the matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you.